And Mr. Spice is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted for manslaughter.
Intentionally and knowingly causing the death of an individual.
Let me look at the indictment. It shows. I don't know why the heading
Heading says manslaughter, but the language.
did then and there intentionally
not
and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? Oh. No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
James Spike.
And Mr. Spikes, you're the person charged with the offense. Okay?
Yes, sir.
Do you have enough money, either you or your family, to post a $800,000 bond?
No, sir, I do.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors. But in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job, were you able to make funds?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez,
Yes,
correct?
sir. Yes,
And that's at 365 Scrap?
Yeah, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment
Yes,
operator?
sir, I do.
So you've always been working, you know?
Yes, I have,
Do you
sir.
have any assets whatsoever? Real property, coin collections,
No,
anything
sir.
like that? And you're asking the court to set some reasonable bonds so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, he was sentenced 4 years GEC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay. Let me take a look at this real quick. And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998, for a 4-year sentence.
All right. 2, possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir,
Nah,
did you want to say that again louder?
I'm thinking about my story. I ain't saying that. I ain't saying that.
You did say something.
Well, I was like, well, I didn't say nothing to you.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right, sir?
Yeah, I was like, $500.
That's what it's set at right now. All right, you can go back with the bailiff.
Can I ask one question too?
What?
I'll be back.
What unfolded in this Bexar County courtroom was nothing short of a legal roller coaster. And it all started with a clerical error that could have changed the trajectory of this entire case. Ronald Spikes stood before the judge facing what was initially labeled as manslaughter, but a closer look at the indictment language told a very different story. The charge read that Spikes intentionally and knowingly caused the death of Rowan Williams by striking him with an automobile. And that language doesn't point to manslaughter. That points to murder, a first-degree felony. The judge caught it immediately, flagging the discrepancy and ordering the records to be corrected. It's a reminder that in the justice system, every single word matters. From there, the hearing shifted to the real question at hand: Spike's bond. Set at a staggering $800,000, his attorney argued it was excessive and called Spikes to the stand to make his case. Spikes testified that he had family ties to the area, steady employment working with his father-in-law at 365 Scrap and as a heavy equipment operator, and claimed he hadn't been in trouble for over a decade, though the state was quick to point out a prior conviction from 1998. After reviewing the probable cause affidavit and a letter of support, the judge granted a reduction, bringing the bond down to $500,000 with strict conditions: house arrest and GPS monitoring at all times. But the moment that truly turned heads came when Spikes reacted audibly to the ruling, a comment under his breath that the judge did not let slide. It was a tense reminder that how you carry yourself in a courtroom can matter just as much as the evidence against you. Justice doesn't just weigh the facts, it watches everything. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.